Welcome to Free Law School. I'm Gregory Swafford. The question for tonight is, if you were sued today, what could they actually take from you? What could they actually take from you? The secondary question is, does your LLC or corporation afford you with the level of limited liability protection that you signed up for? Those are the questions for this evening. We're going to get into it. We're going to talk about the purpose behind the limited liability company. And again, there is no distinction between the corporation or the LLC when we're talking about limited liability protection. Let's talk about what the purpose behind limited liability protection is, or business structure. Let's start with business structure. Business structure has three pillars. Those pillars are represented by asset protection, how we protect the personal assets as well as business assets. The second pillar is tax efficiency. How we form and what we form has a bearing on the amount of taxes that are subsequently going to be assessed against the business or that the business is going to owe. And the third pillar of business structure is one that business owners don't think about a lot. We think about asset protection, we think about tax efficiency, but many business owners give little or no consideration to continuity. What happens in the event that the business owner or founder is not available? What happens if you become incapacitated or that there's a death? Does the business freeze? Do assets freeze? Or is authority in place, written authority in place, so that the business can continue? Those are the three pillars of business structure. Now, I'm going to say this, guys, there's a lot of misinformation, bad information online and on social media. I see it. I'm sure you guys see it. Every day, someone is pushing the idea of business structure, but it's really out of context. Talking about business structure within the context of grants, how to secure grants, funding or structuring your business in order to be able to secure grants, business structure for credit funding. One of the ones that kind of sends me in a different direction. I've seen it, you've probably seen it, is if you have an LLC and an EIN, you can get a real thick stack of credit cards. Well, those things are not really business structure. Those are hacks, okay? And they're not bad in and of themselves, but when we're talking about business structure, there's an order to it. Okay, we're talking about first things first. And if you're not sure about your business structure and your bucket is leaking, then putting more things into it is only going to create more exposure on the back end. Because even things, particularly things like grants and credit cards, those things require the business owner to fulfill certain obligations. If your business structure is either non-existent or faulty, those things are going to leak out and create bigger exposure problems for the business owner on the back end. So I want you guys to be mindful of the context in which business structure is being discussed online. Now, let's get into it. Let's talk about limited liability protection. And welcome for joining. Look, put it in the chat, guys. Put it in the chat. Let me know where you're joining from, okay? Let me know where you're tapping in from and what your industry is, okay? Let me know what type of business are you operating And where are you joining from? Let's talk about limited liability protection because there are so many misconceptions about business in general as it relates to the legal requirements of it. And I'm bound to say this, guys, from the beginning, that these conversations at Free Law School are for educational purposes only. They are not intended to create an attorney client relationship, nor do they create an attorney client relationship, in fact, right? I'm giving you my personal experiences as an attorney that represented small business owners and micro business owners over the course of 30 plus years, right? So there are a lot of misconceptions regarding limited liability protection, even why limited liability protection is necessary. You'd be amazed the number of people who think that the reason that we form LLCs or corporations is for the purpose of starting a business or opening a business. That's not it. There is no requirement in any state that you either form an LLC or a corporation in order to start a business. You can swing the doors open on tomorrow and start selling goods or providing services in whatever arena you choose. That's called a sole proprietorship. That's a form, that's a business form. Forming nothing is actually a business form. It's called the sole proprietorship. Now, why we advise against that in most instances is because when you begin providing services or selling products, there is the potential for liability, the potential for exposure. If the activity that the business is engaged in causes harm or injury to someone, then your personal assets, if you're a sole proprietor, meaning you didn't form an LLC or a corporation. In that instance, you are going to be personally liable. And personally liable means that your home, vehicles, bank accounts, retirement accounts, whatever you own is subject to seizure and sale in order to satisfy that judgment. If in fact you don't write the check. If the liability is assessed against you personally, judgment rendered, and you do not write the check or cannot write the check, then you are going to be personally responsible. So that's why we form the limited liability company or the corporation to avoid personal liability. It creates a shield. Maybe you've heard that term used before in the context of limited liability protection. The LLC, formation of the LLC or corporation creates the opportunity for limited liability protection. And the purpose behind that is to separate personal assets, those assets I just mentioned, home, vehicles, bank accounts. If you're still operating, if you're actually in the side hustle mode right now, that would even include your salary, that your salary could be placed at jeopardy in the event that there is a judgment rendered against the business activity. So the LLC separates out your personal assets. It says that those personal assets are going to be safe in the event that there's a judgment. Now, another misconception. Many business owners believe that forming the LLC, going to LegalZoom, Rocket Lawyer, Taylor, whatever, whoever, however, going to any of those entities and forming the LLC or corporation in and of itself provides protection. It does not. There is absolutely no protection provided by the formation of the entity. You get nothing but a receipt. That's what you get. And a container, very important. You get the container. That's what the LLC and the corporation actually provides. It provides a container from which you operate. You've probably heard it yourself. People say all the time, I'm not bothered by it. I have my paperwork. I'm going to grab my paperwork and it's going to be taken care of. Well, paperwork does not provide protection. Paperwork it does not provide protection in and of itself. The protection comes after you form, but that protection is contingent, and it is contingent upon behavior. So we file for the LLC, we file for the corporation, we get the articles of organization or the articles of incorporation, if it is in fact a corporation. Now that we have our container, our limited liability protection is to be determined based upon the business's activity or the owner's activity going forward. How do you move? Each transaction entered into creates a record and sends out a signal. That's what we're talking about. Sends out a signal. We're talking about everything. Those documents send out a signal, and the signal is going to be read at some time in the future to determine whether or not the owner actually separated from the business when it was filed. That's what determines limited liability protection. Magic word, separation. There must be separation between the business and the owner. And so, what does that look like? Again, it's going to be based on behavior. How does the money move in the company? Is there a mixing or commingling of personal funds and business funds? Or business funds used to pay personal expenses? Does documentation exist for any monies, personal funds placed into the business? We're talking about capital contribution agreement that formally documents that the money is being placed into personal funds or being placed into the corporation or the LLC, or a loan agreement that personal funds are actually being loaned to the business for the operation, such that when that money comes back out the other way, there's documentation demonstrating a separation. How does the owner sign? Do you sign on behalf of the business, ABC LLC, by Danya Dixon, authorized representative or manager? All of those activities send out signals. And we're going to talk about some of the documents, because those documents is where the signals are. And as the business owner is engaging in the activity, you're not really thinking about it. You're just doing what you do to run your business. Even when the activities or the transactions lean over into the personal side, like personally guaranteeing, acting as a personal guarantor for a loan, signing a lease in a personal capacity. Let's look at some of the things that create those signals that could be read as personal when an institution is looking. And so Your business comes in contact with institutions on a daily basis as you're sending out those signals, whether you realize it or not. And those institutions include banks, courts, if we're talking about litigation, insurance underwriters, real estate underwriters. Maybe you're considering taking on investors and they're doing due diligence, they're asking questions. Regulators, auditors, all of those institutions have their own way, their own rules, and own ways of looking at things, but they share something in common. They're all trying to determine whether or not the business operates independently of the owner. We go back to the magic word, separation. That's what everybody's trying to determine. If you end up in court, the court's exploring the issue of separation once they get past the liability issue. Once they decide where liability rests, now they want to determine whether or not the assets being considered for satisfaction is on the personal side or on the business side. And that's determined by how the business moves. That's the only purpose. Let's talk about another misconception, because that's the only purpose of the LLC. Many business owners believe that when they form the LLC or the corporation, it solves all of the problems. Everything's protected. That's not true. The only job that the LLC does is to separate the personal assets from business liability. I'm going to say that part again. The job of the LLC is to separate personal assets from business liabilities. Now, most of you guys are not operating your business with personal assets, even though there are many that do, that make that mistake. Real estate investors leasing residential real estate, and the real estate is titled in the personal name of the owner. That's a problem. There's no separation there. And it becomes a problem also when you move to insure the LLC that's renting out those properties. That's the first thing that the insurer, the underwriter wants to know. Well, how are the properties titled? Who owns them? And you must be able to give definitive answers, and it has to be the right answer. Otherwise, there's additional exposure. The LLC does one job. It separates personal from business liability, personal assets from business liability. But here's the problem that the overwhelming majority of small business owners make. We form the business and we place all of the assets inside the LLC. Everything's titled inside the LLC, and you believe that those assets are all protected, the business assets. Well, those business assets are not protected. Remember, the job of the LLC, it's to protect personal assets. You go into business, you invest, place that investment at risk, fine. You're supposed to be able to leave home at home. That's the personal side. But it's conditioned upon operating properly. Now, what about the real estate, the cash reserves, the business equipment, all of those things that you use, your IP, heck, the brand, all of those things that are owned and titled in the name of the LLC. The LLC nor the corporation provides any protection for those business assets. Remember what I said. The purpose behind limited liability protection is to separate personal assets from business liability. The business assets that are actually exposed to the operational risk because they're inside the LLC, there is no protection for those. So, if a claim is made, here's the light bulb moment. If the claim is made against the business assets are immediately reachable. There is no protection for them. If they exist inside the LLC, the judgment creditor, the person who sued the business and won the lawsuit, they can seize those assets in the event that the business owner doesn't satisfy the check, doesn't satisfy the judgment. Now, that's a big deal for a lot of business owners because when you form the business, you should have given consideration as to whether or not your assets, your valuable business assets, should be placed in the same location as the risk. The risk lives in the operating company, your LLC, or your corporation. That's where risk lives. It's public facing. You see customers, clients, vendors, all of those folks on a daily basis. If anything, if there is a potential for anything to go wrong, that's where it's going to occur at the operating company level. So when we form the business, we have to think about layering for that protection. The LLC gives the operating entity, LLC or corporation, gives you the ability to create the layer between personal and business liability. We need an additional layer for business assets and operational risk. And if you're not familiar with the concept of the holding company, that is the purpose. That's the purpose of the holding company, to create a separation between value, those are your business assets, and operational risk. Let's take a question or two. What's in the chat? When we form the entity, think of it this way. Imagine if your entire financial life was plugged into one extension. Bank accounts, your personal residence, your wages, and then you form the LLC. And it's also plugged into that same power strip. Everything's plugged into the one power strip. And so when the surge happens, and the surge in this instance takes the form of lawsuit, it could be a partnership conflict, it could be an employee dispute, personal injury claim. If everything exists in that one LLC, everything is exposed at one time, including your personal assets, because that means that you did not separate once you filed the LLC. You failed to unplug anything. So I go back to the question. If you're operating a business right now, put it in the chat. If you gave any consideration as to whether or not your valuable business assets should be separated from your operational risk. If you did, put structure in the chat. Let's see what we're working with. If you gave any consideration as to whether or not your valuable business assets should be separate from operational risk, put structure in the chat. Now, guys, there is the real possibility for many business owners that they are actually operating right here, right now, with zero protection. Personal assets are at risk as well as business assets. And here's how that happens. It happens if you're operating the business and you never separated your activity, those signals that are being sent out. Let's look at some of the things that they're considering. Do you have operating agreements? The operate or bylaws. If you formed your business through one of the commercial entities, then you have default operating agreements or bylaws because they had to be submitted when it was formed, when the entity was formed. But what happens is that those formation companies, they create generic or provide generic operating agreements based upon the default statutory rules in the state in which you formed and or operate. They're not specific to your operation. They don't talk, and most of them leave out very important and valuable provisions like voting, like who controls what happens in the event someone decides to leave, who has the authority to move the money. All of those things are considered by the various institutions. They're asking those questions when they are making their classification of your business. The classification could be if we're at the courthouse for the purpose of determining where the liability is going to rest, who's responsible for the harm. If we're talking about banks, then we're talking about qualification and loan terms, insurance underwriting, looking at the potential risk of exposure, looking at modeling data in your industry in order to determine whether or not They're going to provide coverage, what it's going to cost you, what exclusions might apply or exceptions. And all of those things are based upon prior transactions, those signals that the business sends out. Let's see. Banking documents. Separation problems show up when the business revenue goes into a personal account. Maybe it was done once or twice, it was situational, or what commonly happens in many businesses is that the owner injects personal funds into the business bank account in order to shore it up for a period. The signal that's being sent out is that the business, in that instance, is that the business is dependent on the owner. If you're just joining us, we're talking tonight about if you were sued today, what could they actually take from you? That's the question. And the secondary question is, does your LLC or corporation provide you with the level of limited liability protection that you signed up for? Does your company, in other words, are you exposed? Are you exposed? Let's talk some more about those signals that are being sent out. Personal expenses paid from the business account. Business funds pay the mortgage. Unexplained transfers. No payroll, no draw, no distribution or reimbursement system exists. The owner just moves money at will, just because. What about this one? For the business owners that run multiple enterprises, they're running multiple enterprises through one account, as well as those business owners who are running multiple enterprises through one LLC. That creates exposure for everything. If something happens, the most successful venture or enterprise is going to be taxed on behalf of the enterprise that's causing the injury, regardless of whether it's generating revenue or not. Everything is at risk. That's the single power strip. That's what that is. Everything is plugged in to a single power strip. Tax documents, no separate EIN, personal deductions mixed with business expenses, owner taking money without classification. How do you sign your contracts? Do you sign on behalf of the corporation, or are there lapses at times where sometimes you sign on behalf of the LLC or the corporation, other times it's personal? Do your customers think that they're actually doing business with the LLC, or are they really doing business with you? What's their perception? It matters. What about your service agreements, vendor contracts, POs? How are those things engaged? How are they signed? What do your signature blocks look like? Here's where we get into problems on the contracts, where invoices are issued personally, signature block says the owner name, but there's no title existing there. Contracts use the word I as opposed to a company name. What about your licensing and permits? What is stated in those documents? So here's the point. Operating the business is more than just forming the entity and going out and doing business. It's inevitable that the pressure event is going to arrive. It's going to happen. It's just a matter of time. And again, when I say pressure event, I'm talking about lawsuits, loan applications, insurance applications, audits, due diligence, whatever. Those events are going to occur. And at that point, you can't run and clean up the paperwork. The documents are there or not there. That's an even worse situation where there are no documents, they're non-existent. But in most instances, the documents are there. They just don't reflect what the business needs to reflect in order to avoid liability or loan application denial or insurance coverage denial or investors walking away. And all of it is based upon how the business owner moves. But the big deal for many business owners is to avoid the personal liability. That's the one, the court. That's the institution that most business owners are leery of. They want to know, how did the money move? Who's in control? Who stood to benefit from the business activity? Who absorbs the risk? That's a lot of questions. Maybe you didn't even you operate your business on a daily basis. Your business is successful, and you never even really gave any thought to those issues. Many business owners don't. Some do. I get the conversations about the gut feeling that I knew I should have had something else, that there was something that was missing from my structure. Many business owners, they feel that. They just can't describe it. They don't know what it is that they need to fix. And that's what this conversation is designed to address. Because the business can be successful, generating revenue, scale, employees, all of the signs of success. And the assets, personal and business, be totally exposed with no awareness of the exposure. And that is because success has a way of masking or hiding the exposure. Nobody notices exposure during the good times. And the reason for that is because nobody's knocking on the door, or you're not at the bank applying for something, so they're not looking at your documents. You're not engaged with any other institutions. There is no lawsuit. Then everything feels fine. Business structure is never tested during calm periods. It's only tested during the pressure events. But if you're not in tune to how you're operating, if you're not really familiar on how you should be moving and sending out these signals in these transactions, you're not going to find out until you find yourself on the back end of the stress event. And the back end means that the classification has already been made. If the bank account shows that the business is dependent upon the owner, then the denial is all but a foregone conclusion. Or possibly the bank asks for a guarantee. But the guarantee has a way of eviscerating the limited liability protection, making it evaporate. Poof, it goes away. When you sign the personal guarantee, you waive any limited liability protection as it relates to that debt. And if the business owner is not mindful or careful in how he or she operates the business in other areas like contracts, those other documents we talked about, how they're signed, licensing, permits, do they exist in the name of the business or in the personal name, in the business owner's name? When you combine, when you accumulate those signals from different areas, then the classification of the business becomes personal. One or two transactions by themselves will probably not classify the business as personal, depending upon how egregious those activities were. But where the behavior becomes repetitive, the owner continuously moves money and pays the mortgage out of the business bank account because it's her money. I can move it like I want to. That sends a personal signal. Where those personal signals accumulate, then the documents, the operating agreements, the bylaws, those documents that reflect how the business intended to run from the beginning, those documents become irrelevant. Nobody's reading them. And the reason they become irrelevant is because they no longer reflect or they no longer align with how the business moves. It's one thing to say that it's the intent of the business to operate in this manner. Remember, the operating agreement, it's the rule book for the business. It lays out everything. Well, it's one thing to say that in the documents, but if the business behavior drifts over time away from the documents become irrelevant. And the institutions, whether they're courts, banks, investors, underwriters, auditors, regulators, they begin to focus their attention on the activity. Forget about the paperwork. That's just what you said. We're looking at how you actually move. That's how paperwork becomes irrelevant. And it usually surprises business owners. They feel blindsided. They're like, I've been coveting this paperwork the entire time. I pay my annual fees on time. I make sure I file my annual report on time. They don't have to ask me for the money. It's always, doesn't matter. That's just a compliance thing. That has nothing to do with the question of what happens if something goes wrong. Paying your fees on time and being in compliance simply means that you, as the business owner, has performed or have performed the minimum requirements necessary to be recognized by the system. That's all it means. It does not address the question of what happens when something goes wrong. That's a behavioral question. And that's why business structure is not a legal question. Everybody thinks that it's a legal question. But I just gave you 5 institutions outside of the court that your business encounters and sends out signals to. And all of those institutions, including the court, is looking at behavior. You don't even have to bring documents unless we're arguing about a contract if you're in court, because the determination is going to be made and can be made based upon how the business moves, how the business owner moves. Those signals. Business structure is about behavior. And the reason it's about behavior, if you watch the behavior for long enough, it's going to leave patterns. And over time, those patterns become repetitive. And when those patterns become repetitive, they afford the institution sufficient enough information to classify the business as either independent of the owner or dependent upon the owner, separation or dependency. And so I engage in these conversations for the purpose of making business owners, you guys, aware of the exposure that exists on a daily basis. I'm going to run over it one more time. If you're just joining us, we're talking about if you were sued today, what could they actually take from you? And for many business owners, the revelation is earth-shattering, because for many business owners, the answer is they can take everything. If you're not clear on how to move, then that means that your personal assets are safe. If you form the business backwards and only formed an LLC or a corporation, no holding company, no trust, then your business assets are at risk and reachable because they're located in the operating company where the risk is located. That's how we talk about the fact that most businesses are built backwards. That's why I asked the question. At the time that you formed your entity, did you give any consideration as to whether value and risk should be separated? Here's how it happens backwards. Most business owners don't. The first thing they think about is forming the entity, getting the paperwork, getting an EIN, opening a bank account, and commencing business activity. Well, where was the consideration given to separating the value from the operational risk, the business assets from the operating entity? None. Not until a crisis or a pressure event occurs. That's backwards. The first thing that the business owner should consider is, where should I place the assets? Where should everything be placed? Because business structure has an order of operations. Remember that concept? They may have not taught a lot about business or many things back in those grade school days, but I'm sure you remember the order of operations. And it has the same principle here when we're talking about business structure. If you want the right answer, then there's an order, right? There's a sequence of steps that must be followed. And if you do things out of order, you're not going to get the right answer. And in this instance, we're taught the right answer is limited liability protection, separation. Separation. Liability can be imposed upon you and places your personal assets at risk. And because you have the single entity, the LLC, where everything resides, all of those assets are at risk. So, again, that's to create awareness. Now, what do you do with this awareness? I practiced law for over 30 years, represented many business owners, represented myself in many transactions, right? So, there are certain things that the business owner can do for his or herself, and that's business structure. You need to be literate. You need to be structurally literate. We talk about financial literacy. When you get ready to form a business, you can go to all these different places, SBA and here and there, and incubators, and the list is endless. And they talk about all these things: how to form a business, how to get capital, how to clean your credit, how to do this, how to do that. But nobody talks about structural literacy. And one of the reasons is because many business owners default to those commercial entities to form the business, thinking that they equate business formation with business structure. And it's not. All those people are doing is going to the Secretary of State on your behalf and send you the receipt. And you conflate protection with the receipt. But it's not. One of the reasons that I formed Free Law School is, apart from seeing so many business owners over the years get blindsided with the exposure and the seizure of their personal assets after a judgment was rendered. And reflecting on the situation, it's like those things could have been avoided. One, the traditional way is if you had counsel. But many business owners skip the legal part when they're forming a business. They just skip it and form the entity and start doing business. So, the serious business owner, I call that person the prosepreneur. And you may be familiar with the Latin phrase. It's used in the legal profession, the se. It refers to a person who represents his or herself in court. So we're not talking about representing yourself in court, but we are talking about not outsourcing your understanding of the environment in which the business operates. You need to understand that environment for yourself. You're making decisions on a daily basis that have lasting consequences. So the meaning of the word pro se is for oneself. That's what it means. For oneself. So we put pro se and entrepreneur together to represent the business owner who takes account for their own understanding of the legal environment in which the business operates. And again, it's a behavioral thing. It's not even so much legal because we're not talking about statutes. We're not talking about laws or anything like that. We're talking about how you operate, how you behave. That's what keeps you safe. That's what everybody's going to look at. The loan officer is looking at it, the underwriter, the judge. Everybody's looking at your behavior. So understanding how to move is what keeps you safe. It doesn't matter what state you're operating from. It doesn't even matter what country you're operating from because globally, every country has some form of the limited company. And it all asks the same serves the same purpose. And that is to separate the personal from the business liability. No matter where you go, France, Germany, South Africa, Australia, the UK, they all have their own names for the limited company. Here in the US, we call it the LLC. It's limited in the UK, Sorrel in France, Morocco. They all have their own names, and it's all about the behavior. That's the point. That's why I bring that up because I want you to understand that it's not, you don't have to go around and figure out what the laws state. Forget about the laws. It's about understanding how to move. And so right now, for some of you guys, business owners, operators, this conversation may have gotten a little uncomfortable. Considering the fact that your business assets, if you're operating right now and you're operating out of one entity, your business assets are totally exposed. No ifs and ands about it. We don't have to run a test. We don't have to do anything. Those assets are exposed. Now, the good news is that if there are no pressure events, particularly litigation, involved right now, then you have the opportunity to fix your structure. And the reason I bring the absence of pressure events up is because once those things happen, once you're engaged in claims, litigation, debt defaults, and all of those things, you're precluded in many instances from moving assets at that time. Generally, the court is going to unwind any and all of those transactions as fraudulent transfers. That's why it's so important that we get the structure correct and in place up front. That was the best time. But now is the next best time if you're not engaged in any pressure events. The business owners who have the LLCs and who are not sure, who may see some of their activities and what I described here tonight, how you sign, whether or not you guarantee anything, what your paperwork says. If you see any potential exposure there, then the thing to do is to evaluate, to see where the exposure lives and get it fixed. And so what we did at Free Law School was we created a diagnostic. You can take the diagnostic. It is going to look at various aspects of your operation. It is going to look at ownership. It will ask questions about control and asset location. It is going to ask questions about risk and continuity. All of the things that combined equal business structure. You can take the structural exposure check to see where your business or personal assets may be exposed. The link is in the description. It's complimentary. Take the structural exposure check because for many business owners, you're totally exposed, personal as well as business. Whatever you thought was protected, it's probably not. Discover it for yourself, though. To sit here and to listen to this conversation is one thing, but to actually step back and answer those questions for oneself. And nobody sees this but you. You're going to see it. If you decide to do something with the awareness, then you can book a clarity call and we can have a consultation about mapping out where your exposure lives and what you can actually do about it to fix it. That's the clarity call. But that should come after you take the diagnostic. And if you decide to act upon the awareness, because some people are not going to act upon the awareness. Let's see what's in the chat. We'll try to take one or two. Hello, hello, hello. Well, no questions. In that event, again, the description has the link to the structural exposure check. Take the check and learn where your exposure exists on a personal side. This is going to tell you whether or not your personal assets are exposed. If you're only operating with the LLC or the corporation, your operating company, then your business assets are at risk. If you'd like to talk about how to fix that, what it takes to do it, then that link that's in the description, also a link to the same link to the clarity call. I thank you guys for joining the Prosepreneur Network this evening and enjoy the rest of your evening, and we'll talk again.